So, Steve, good to see you again.
Yeah, good seeing you.
Yeah, we have another case that cited Johnson v. McIntosh, but this time to criticize it. Although, what we're going to do as we go through this, I think will show how shallow the criticism is. If I can just say ahead of time, I think that we're creeping up on some alternate version of the Emperor's New Clothes, and the old original 1837 story is about two tailors who, rook the emperor basically and give him nakedness. But I'm thinking that what happens when people become restless? They don't like the emperor's clothes. They wish the emperor would wear some new clothes. And I think that there's a theme somewhere in there that we're going to get to. You want to say something about that before I was going to share a screen about the case that we're going to talk about. You want to say something?
Well, I think that the what we're going to examine is a confession, perhaps is the right word, but certainly an elucidation or an effort to illuminate the domination system with embedded within the what's called federal Indian law, the ideas and arguments that have been accumulated over generations to deal with native issues, the issues of native nations and peoples. And it's interesting. Now you have kind of, I don't know if existential is the right word for it. The whole, what is the nature of the existence that we ought to be living instead of what we are living and experiencing. So there's an ideal that this judge, we're going to be examining his words in particular, but there's an ideal that he has in his mind that he's using to compare the actual system that they're using to what he has in his mind as far as what it ought to be if it were living up to its to the principles that he holds dear, let's put it that way. And that'll be revealed in how we examine his wording and the extent to which he's actually condemning it, but then still condoning the use of it. So it's kind of a weird thing, is disavowing it, but yet still utilizing it, and
Yeah.
going
Similar,
along with it.
similar to that Ninth Circuit uh, judge that we saw a couple of sessions ago, who agreed that the Indians shouldn't get anything, but we shouldn't be calling them Indians. Let's
Yeah,
be
yeah.
respectful.
Well, I mean, it is, yeah, we're using the system of domination, but my goodness, let's not call them a inappropriate name.
Yeah, let's don't call it domination. Let me
Well,
just
that, yeah, that's a good point.
let me share the screen here. So, okay, whoops, there we go. So this is the case. October 9. You can see it's very, very recent. Supreme Court, State of Washington, the Flying T Ranch versus the Stillaguamish Tribe of Indians and the Snohomish County also involved in it. Okay, and so basically, what it was about is the Flying T Ranch was suing the Stillaguamish, saying, "We own the land that you claim to own. We've got it by adverse possession." And it's a whole long, complicated thing about uh, what the case is about is whether or not particular type of property law can apply to the Stillaguamish. If it did, then Flying T Ranch would win, but they're saying no, that doesn't apply because it requires well, what it runs up against is the so-called sovereign immunity of the Stillaguamish, and then that sovereign immunity is in the way of Flying T Ranch, so they just basically they knocked down that Flying T Ranch's lawsuit. But the interesting question is they trying to decide how when do you know that the sovereign immunity has been waived? And as we're going to get into in some detail, they follow the basic line of federal anti-Indian law, which is that the Indians can waive their sovereign immunity, but so can Congress, because Congress has this total power, and it can say, "We hereby declare that Stillaguamish can be sued. We're going to waive the immunity." Uh, so let's just dive. So here, this is the opening of the case. Indian tribes may be sued only under two circumstances. One, when the tribe waives its immunity, or two, when Congress unequivocally abrogates tribal sovereign immunity. Now, we've seen this over and over again. The idea that Congress has some total power, that it can abrogate tribal sovereign immunity. We also know that Congress, we've seen that even in the so-called pro-Indian case of McGirt v. Oklahoma, that it rested on that Congress hadn't yet extinguished the Creek Nation, but it could extinguish it at any time. So this is basic, this is the root of the domination that is inherent in federal anti-Indian law, is that Congress claims a right of domination over the original peoples here. And so the very first sentence of the opinion, it lays out that law. We're going to look at whether the Stillaguamish can be sued, and we want to say at the outset, we're either going to have to find that they waived their immunity or Congress abrogated it. Now, at the very conclusion, we're skipping all that text in between that I was trying to describe. The conclusion is that tribes are immune from suit and may be sued only where a tribe waives its immunity or when Congress has unequivocally abrogated it. An act of Congress is necessary to create it. So here, this is in a nutshell, this is the statement of the domination. All right, would you agree with that?
Yeah.
So,
well, with the caveat that there's no appearance of domination whatsoever in any of this language. It's just invisible behind all this verbiage. But go ahead.
Yeah, no, exactly. I'm glad you said it, because when you say unequivocally abrogated, it's like, well, that sort of sounds like gobbledygook, doesn't it? To a lot of people, abrogate, what does that mean? And then unequivocally abrogate.
Yeah.
So,
Yep.
And hidden behind that tiny phrase is the actual domination, the fact of the domination.
Or the claim of a right of domination.
Claim of a right of domination. So we get to a Judge Mungia who's he files a concurring opinion, and it means he agrees with the decision, but he wants to add some few thoughts. So here, first sentence, I concur with the majority opinion, and yet I dissent. What is he dissenting from? From the racism embedded in the federal case law that applies to this dispute. So this is already right in his first two sentences. There's a little bit of a dilemma here, because he agrees with this power of domination, which has not been called power of domination. It's been called unequivocally abrogate. He agrees with that, but he doesn't like the racism embodied in the cases that uphold that. So he's not saying he disagrees with congressional power. He doesn't disagree with the domination inherent in it, but he doesn't like the language it is couched in. So that's why I said it's like the emperor's new clothes. He's not really complaining about the emperor, but he's complaining about the emperor's clothes. And I hope I'm not being too harsh, but I'm sort of jumping to the punchline here. And so he starts out, federal Indian law is a product of racist beliefs endemic in our society, in our legal system. He starts out, it's certainly necessary to follow case law. In other words, the case law that has the domination, we have to follow that domination case law. But at the same time, it's important to call out that the foundation is based on racism and white supremacy. Now you might wonder, well, so if you're saying we're going to obey the emperor, but we're going to reserve the right to criticize his wardrobe, then is it really worth your time to do that? Shouldn't you be digging into whether or not you want the emperor around? And
well,
so
I think that keep going. Yeah.
no, I'm just saying. So his point is that he doesn't want people to have any doubt that the court disavows and condemns the racist sentiments, beliefs, and statements. But note, he's not saying they disavow and condemn the decisions, just the language of the decisions. That's what we're going to dig into. Go ahead.
Well, I was going to say that if after it disavows but still uses those sentiments, beliefs, and statements, in other words, the reasoning process that was applied to various cases across the generations has been representative of this complaint that he has against that system using these specific terms, but yet the reasoning process is what they're still using to reach their decision.
Yes.
So they're disavowing it, but still maintaining it and sustaining it for yet another generation or however many generations it might exist, right?
Now notice there's a footnote here with his first sentence, okay? And now notice in the footnote, he says he's quarreling with the majority, talking about whether it makes any difference what the Stillaguamish are going to do with the property. That's the arcane property rule I was talking about. But he says that's irrelevant. As domestic sovereign nations, it does not apply regardless of what the property is. Now, where's the phrase domestic sovereign nations come in? We're going to find that. So he's relying on that concept of domestic sovereign nations.
Well,
Yeah,
let's stay up there for just a moment if we could.
yeah,
Okay, to this text right there. Okay. I just wanted to make sure that I'm adding, and probably already made the point, but that every time you see words such as racism and white supremacy, once again, it's that claim of a right of domination in the background here, but he's using those names to identify that. I just want to make that key
yeah,
point.
yeah, yeah. So this is what's useful here, as you said. It's very unusual to have a judge
Oh,
dive into this kind of stuff. And exposed this, the language. So he's talking about federal case law arising from those racist underpinnings, and particularly Cherokee Nation v. Georgia. And we've talked about that, the second case in the Marshall Trilogy. After Johnson v. McIntosh said the U.S. held title to the whole country, the Cherokee Nation sued Georgia under the treaty it had with the U.S. And the Supreme Court, Justice Marshall said, we're not even going to hear your case because you don't have the right to come here because you're not a nation. Even though you have a treaty, you're not a nation. And what are you? This is the famous line. And this is what Judge Mungy is quoting. He says that the tribe is like a ward to his guardian. All right. Now, we're going to look at Cherokee Nation in a moment, but ward to the guardian is the basis of the so-called trust relationship. And that is without reference necessarily to this phrase ward to guardian. Trust is a form, ward versus guardian is a form of trust, so-called, and the federal power is often exercised in the name of its trust relationship. And many, many native peoples bring cases saying you owe us a trust duty. So he's criticizing the phrase ward guardian because he says that it presents the tribal members as children. But once that phrase has been erased, if you read trust relationship, it doesn't sound like that anymore. So the language, if you get rid of ward guardian and just keep the rest of Cherokee Nation, this is what you get. Here's Cherokee Nation. First of all, right at the top of the page, this is not the first page of the opinion, but selected page 30 in the opinion. Indian Territory is admitted. By whom? We don't know. It's certainly not admitted by the Indians. Admitted to compose a part of the United States. That's the key piece that Johnson said, is that all the land is actually part of the United States. Further down that page, it says, well, who are these people? It says they may be perhaps denominated domestic dependent nations. Now, doesn't that sound an awful lot like domestic sovereigns? This is the phrase that Judge Mungy used in footnote 1, is boosting them up. These are domestic sovereigns. They can do what they want with their land. Well, where did he get that concept? He got it from Cherokee Nation, the very case he's criticizing. So he says, this is Marshall. We assert a title independent of their will. That's Johnson v. McIntosh.
yeah,
Claim we own their land.
right.
It says, meanwhile, they're in a state of pupillage. Their relation resembles that of a ward to his guardian. The objectionable phrase occurs after the point at which the real domination has been applied, which is we assert a title independent of their will. Now, you and I criticize Cherokee Nation because of that sentence. They occupy a territory to which we assert a title independent of their will. We say that's the claim of a right of domination based on the notion that Indian Territory is part of the U.S. What Judge Munger is worried about is the last sentence, the word to his guardian.
Yeah. Well, there's so much to this. For example, the word title there.
Mm-hmm.
If we trace that back into the Johnson ruling, which is where that comes from, then we will realize that that is a synonym for ultimate dominion.
Mm-hmm.
So they asserted the ultimate dominion to be in themselves. That's the basis of quote unquote title. And those kinds of connections have to be kept track of in reading these types of decisions. And so it is interesting what you're saying. The more key point is, is this business of asserting a title to their land independent of their will, meaning against their will, but he's going to say, oh, just independent. And that avoids the usual phrasing against their will. And so, but he's focusing in merely on this ward guardian analogy that Marshall has used and that the court has used in this particular decision.
And so if you got rid of that, let's say we go with Judge Mungia and we erase the last sentence. Let's say we redacted it.
Yeah.
Would the problem be solved? No, the problem wouldn't be solved. The problem hasn't even been touched.
Well,
Close.
and he's avoiding the most foundational
Yeah.
nature, the foundational premise of the system he's criticizing.
Yes, exactly. And notice this, where was it? Here it is. They're considered, as well as by itself, being completely under the sovereignty.
Yeah.
That's the essence of the claim of a right of domination. Anyway, so that's Cherokee Nation, which has been criticized for a little phrase here that sounds, oh, it's troubling. It's a troubling phrase. Let's get rid of that phrase. Let's admit that it was there. Oh, nasty, nasty Marshall. He put that nasty phrase in there. Well, what else did Marshall say? Oh, I don't know. I don't remember that part.
Well, can we just
Yeah.
hold tight for just a
Sure.
second? The go scroll up just a bit, or the other direction, sorry, down.
Oh,
Yeah,
yeah.
down. I'm dyslexic. Okay, so but the under the sovereignty. So if we remember that sovereignty is defined by Jonathan Havercroft as a unjust form of political domination
Yeah.
that limits human freedom, that would be very relevant to the interpretation of this phrase. And
Yeah.
so under the domination is my point, is that
Yes.
that's the
Yes.
synonym, right?
Yeah. And if somebody wants to deal with the domination, this is what they're going to look at. And the
Yeah.
dressing that's put on Ward to the Guardian, you're going to say, oh yeah, that was that shirt he was wearing. It's got a bunch of holes in it now.
Well, and also look at how the great father, the G is capitalized,
Yeah.
the word father is capitalized.
Yeah.
F in father, the G in great, okay?
Yeah.
So
Yeah.
that's an honorific device
Yeah.
showing the elevation above the lowercase, isn't that interesting? Uppercase, lowercase,
Yeah.
framing of this way of writing about these issues.
Yeah. Now, you know, Steve, if we really wanted to point to the silly side of this, we could say, we think that that's really unright, that it's not right that he capitalizes president and great father. That was a nasty thing that Marshall did. So it put them back in lowercase. Problem has been solved? No, I don't even think the problem's been looked at.
Right, there you go.
Okay, now we're back to the dissent. So he's talking about this superior to inferior. So we're talking, he's describing forms of domination. Although I'm not sure that teacher to student, most people I don't think would think, geez, the teachers dominate in class, but of course that's what teachers do. I've been one for long enough. So now he talks about the lone wolf case, okay? And lone wolf quoted another case, US v. Kagama here, and this is where he doesn't like this language. The Indians are the wards of the nation. All right. So he's criticizing Lone Wolf for the same thing. But what else did Lone Wolf say? Let's look at Lone Wolf v. Hitchcock here. Here's the this is this is what else. I don't need to show you he gave you the full quote of the business of what Lone Wolf repeating the word to the Guardian, but this is in Wolf's. The right which the Indian had was only that of occupancy. The fee was in the United States. That's the same thing you were just talking about. That comes from Johnson v. McIntosh. Fee is another word for title. And so this is what, and it says the occupancy could only be interfered with, and it's always struck me as interesting, only be interfered. Now, only the dominator can dominate you. Just keep that in mind, okay? Only interfered with or determined by the United States. Plenary authority over the tribal relations has been exercised by Congress from the beginning. Now, if you're going to criticize Lone Wolf, that's what you should be criticizing it for, right?
Well, one of the things,
Yeah.
and so notice, and this is a subtle point, but notice how he's referring to the right of occupancy, and then he says, where is it? Okay, the fee. So most people would not know, most attorneys wouldn't know what the word fee means, and that's simply another synonym for domination in a sense. But it was in the United States subject to that right. Well, which right? Occupancy. So in a sense, it really is a deception. because Marshall's making it seem as if, or I think that's correct to say it was Marshall, as the,
Beginning, lone wolf is
oh,
just,
I apologize. So Lone Wolf, this
yeah,
is from Lone Wolf. So,
right.
but the court, in other words, is using the same kind of language that Marshall initially used in the Johnson ruling and matching that here and making it seem as if fee, or excuse me, making it seem as if occupancy has some kind of power against a fee title, and it has zero power against a fee title. So that's where the deception comes in.
Exactly.
And if you said, if you reversed it, it would look more accurate in terms of saying that the occupancy is subject to the fee, meaning subject to the domination of the United States.
Yes. Yeah. Yeah. So this is the thread that runs through all of these cases that
Right.
constitute federal anti-Indian law and which are the real core of what that's about, regardless of whatever dress what seemed appropriate at that time in 1903 or 1823 or in 2025. And I think you used the word recently that there's a kind of existential crisis going on in the judiciary at this point, it seems to me. And I think we can talk about that more later, but we've seen it in recent opinions like this one where the judges are getting uncomfortable. Oh, geez, I don't know. This is pretty nasty sounding stuff here. It's like a naked statue. We should put a fig leaf over it or something like that. They're not talking about getting rid of the decision. They're talking about how do we avoid saying how corrupt the whole thing is, how filled with
Yeah.
pretensions of domination that it is.
Now,
And
if you
not
go to the earlier part of that, just okay, right there. So, well, come down a bit the other way. There you go, right there. So notice that this now it is true that in decisions of this court, the Indian right of occupancy of tribal lands, whether declared in a treaty or otherwise created, has been stated as being sacred, or is sometimes expressed as sacred as the fee of the United States. But notice that they're using Johnson versus McIntosh and Cherokee Nation to support that particular statement.
right.
And so that would help people listening to this broadcast to understand that this is supportive of what we've been stating.
Yep. And notice here, after he says it's as sacred as the fee, and so sacred using religious imagery here in the fee, like the ownership right, okay, is a sacred thing, he's saying, right? And of course, occupancy doesn't have that, but it's just as sacred, he says. But he goes here, but, and none of these was a controversy, none of these cases was there a controversy between the Indians and the government respecting the power of Congress to administer the property. All right. So
Yep.
he's talking about uh, here, Congress possessed a paramount authority. This is what's by, and notice here, by reason of its guardianship, there's your ward guardian, right?
Yep.
It can even be applied contrary to the strict letter of a treaty, right? So
And the other thing I want to jump in just for interject for one moment. When we approach this type of language about guardianship and guardian ward and so forth, as if it's a fact and lose sight of the fact that it's an analogy and a metaphor that's being used to think through this, I think we're not enabling people to realize the extent to which all of this careful crafting of language is really what the whole point of the exercise is. How do they maintain this system that they've created and pay attention to these types of analogies, but we lose sight of the fact that it's an analogy or a metaphor when we state it as a fact. It's a fact that it's a guardian and that this guardian has a ward called, i.e., Indians, right?
yeah, exactly. Metaphor through and through.
Yes.
So now we're back to the judge's opinion, and this is he doesn't dig into McIntosh except to say that he says the same things that we have talked about, doctrine of discovery. He even brings in, which is really unusual, the fact that Johnson relied on Christian discovery here, and he slips out of it again when he says European countries. He talked about Christian peoples. And this is where, so he acknowledges that this is the root of the whole thing. Okay. Now, what does he do next? He says, oh, I like this because the viewing of the ship, this is, he's somehow is plagiarizing your notion of the view from the shore and the view from the ship. The view from the ship was enough to give them title. That's what basically what Doctrine of Discovery said. And then he just repeats the whole thing. The U.S. controlled the land, etc. He's not actually criticizing that because he's already agreed with the majority that the U.S. can decide the Stillaguamish don't have sovereign immunity. So he's saying, look how horrible this is. And at the same time, he says, but that's the basis of our case, and I agree with it.
Well, okay, so let's go back to that for just right there. No, the other direction.
Right here.
What you were just focused on.
Yeah.
Okay, right there. Viewing the land from the ship was enough to give them title. That's actually inaccurate. If you want to get technical with the international law doctrine, effective possession basically is what there has to be more than simply viewing the land. And there has to be certain actions taken that demonstrate an effective occupation, or meaning the foreign occupation, them coming in and seizing control. That's why they put a fort up, or they put certain a garrison of soldiers or what have you, to show that they now have control, and they have to symbolize that through arms or through implements or symbols of domination. And so there's more to this than what he's stating here, is my point.
Yes, oh, I'm glad you said that. And I'm thinking of your ceremonies of possessions that you see
Yeah.
all these pictures come, put the cross down, kneel down, put the sword down, that sort of stuff. That, yes, physical. There had to be physical action on the land. So you're right. This is oversimplifying what
And while we're on that, the federal government as conquerors, okay, that's stating that as a fact. It doesn't say as purported conquerors. There's no hedging. There's no calling this into question, as you already stated. It appears to be taking it at face value, but
Yeah.
where's the critique of these notions?
And where is the example of the Congress? This is where Johnson v. McIntosh, John Marshall said, this is what he said was the extravagant pretension of his decision, was that he was converting discovery into conquest. There had been no conquest, certainly not of the entire continent. And since there was no conquest, he had to have some basis, and that basis was discovery. And yet he says that's an extravagant pretension.
Well, and he's pretending to convert discovery into conquest. That's why he's combining those words together in that manner. He's actually confessing, admitting that he's pretending to do that. In fact, the whole government is, right?
Lie.
Yeah.
So not only is it a superficial view of what the doctrine meant and what it required in terms of physical, but it also borrows without any, he doesn't say, wait a minute, where's this conquering business? Let's go back and look at Johnson v. McIntosh, where Marshall doesn't say they were conquered. So why are we saying they're conquered? Again, we're seeing, rather than critique the core assertion of the claim of domination, he's just dealing with the trimmings of it. And so then he goes on, he says that it's time to call this out. Okay, he's going to call it out. So how does he start? He's talking about how the courts have taken steps to address some of the errors of the past. Now, the errors of the past are using the bad language. Let's be clear about that. We're going to see that. It's not the errors of the past in making these decisions. It's the errors of the past and how they talked about these decisions. So he says, this is really disingenuous. He says the U.S. Supreme Court now recognizes sovereign authority of tribes, etc., and he cites the Upper Skagit Indian tribe versus Lundgren. Now, we're going to jump back and forth a little bit, because if you look at the actual case, Upper Skagit, this is written by Gorsuch, by the way, the court didn't adopt it. It says, for its part, the tribe relied upon decisions recognizing this. He doesn't agree with that or disagree with that, Gorsuch. So it's not really correct to say the Supreme Court recognized that. It said that in this case, it was argued that, but the court didn't decide that.
Yeah.
So then he also quotes Michigan v. Bay Mills. This is now supposedly recognizing an error of the past. let's zoom down to Michigan against Bay Mills right here. As domestic dependent nations, doesn't that sound a lot like domestic sovereigns? Indian
Mm,
tribes exercise sovereignty subject to the will of the federal government. This is the phrasing you were saying should have been done in Lone Wolf, is that the subjection has to be made clear. Subjection means, notice it says among much else, that Congress can abrogate immunity as it wishes. And the Bay Mills Court, the Supreme Court said, if Congress had done this, Bay Mills wouldn't have any valid grounds to object. That's similar to what Gorsuch said in McGirt.
yeah.
So rather than
Well,
saying,
and says, but Congress has not done so,
yes,
is the concluding thought there, right?
yeah, yeah. And so if we back up here, why are we looking at Michigan? Because he claims that this is steps to address the error of the past. Where was the error of the past addressed? Michigan's Bay Mills, the Supreme Court said that Bay Mills Indian community had sovereign immunity. Oh, great, sovereign immunity. But why did they have sovereign immunity? Because Congress hadn't taken it away yet. Did that? Where's the error of the past been corrected?
Yeah.
So then,
Well, where is on the part of this judge,
yeah,
where is the deeper examination of the founding principles of this system that he's calling into question, apparently?
zero.
Yeah.
So here, another case he cites, Holland v. Bracken. You remember that's a child welfare case, and that was totally celebrated by so-called progressives who said, "Oh, isn't it wonderful? The Indians win." Well, what does that case say? This is notice that we begin with. This is the beginning of their analysis. All right,
Yeah.
and right at the top. In a long line of cases, we've characterized Congress's power as plenary and exclusive. And then they go through quotes: plenary power, plenary and exclusive power, plenary authority. Notice that's Lone Wolf, by the way. Paramount power, plenary power of legislation. Leave little doubt that Congress's field is muscular. Now, isn't that an interesting thing? Muscular. You think, does that sound a little bit like physical domination, doesn't it?
Well, and where's the understanding or acknowledgement that every time the phrase plenary power is being used, it's a replacement for domination, just
Yes,
another way of stating a principle of domination.
yes.
It's not
And
here. Yeah.
yeah, exactly. And the last line there, I wanted to quote from the case: Congress has plenary authority to limit, modify, or eliminate the powers of local self-government. All right. So is this any evidence that there's been an error of the past? I mean, you're right. If you took plenary, you said we have characterized Congress's power as domination. Congress possesses domination. Congress exercises domination. Thoroughly established that Congress has that's the meaning of the Bay Mills case. I mean, of the Brackeen case. So the
Yeah.
three cases that he cites as being, wow, we're really moving forward here, we're showing some progress. All of them, this is like not even a hole in the bucket. There's no bottom in the bucket of that argument. And notice then, our court correctly holds that the Stillaguamish have sovereign immunity. Only Congress and the tribes themselves return. Wait a minute. There's that only Congress again. Only Congress. Well, who else would do it? Shouldn't it be that the tribes retain power? How do you get the only Congress and the tribes? How does Congress get in here at all? The only way Congress gets in here is going back through all these cases that, well, we just saw Helene and Michigan and so on, all citing back to Johnson, Cherokee Nation, Worcester v. Georgia. The whole structure is right there in that phrase.
Mm.
And it's not being criticized. It's saying our court correctly holds this. He's
Yep.
agreeing. So now we went through those three cases. Maybe, oh, here we go. He gets down where it's near his end here. We're bound by the precedent. He's not even criticizing the precedent. The precedent is the claim of the right of domination. In every single one of those cases, the precedent is there. That's what the precedent is. He's not being critical of it, but he doesn't like the underlying racism and precedents that are woven into the opinions. This is why I say it's like the emperor's new clothes. So
Well, let me jump in here and make
yeah,
a
please.
statement that I think is super pertinent, and that has to do with the limitations of a race-oriented framework to critique all this. Because
Yep.
if the most you're going to say, oh, it's racist, it's prejudice, and this sort of thing, how does that in itself, just that alone, get to the deeper kind of examination that we're wanting to engage in here? And why isn't this judge really going to that deeper level, that foundational level of an examination of the system that he's apparently condemning and critiquing?
Yeah.
He's satisfied to just call it racist. Oh, it's based on white supremacy. In what way he's kind of alluding to the Yusuf Guardian Ward as being the real key example that he can point to, but it's also the least damaging to the system that they've created.
Yeah. And when you, the work, the incredible work that you've done with unearthing the Vatican archives and the rest of it is that's the thread of if there's a ideology, let's call it, he calls it ideology, that if that's woven into the very fabric of the opinions, it's Christian discovery. It's the Christian peoples. It's tied together with the so-called power of Christendom, which was the power of the Pope. That's the piece that is like a clear thread throughout it. It's not like the Pope saying, we want you to go get those dark people. No, we want you to go get those non-Christians,
Yeah.
those
Yep.
infidels and pagans. That's why you're going to attack them, is because they're not of the proper religion. And so I think that if we're going to start doing serious, we at least have to pay attention to the rhetoric on that side. In fact, in Johnson v. McIntosh, Christian is mentioned more than the so-called word savage. So,
Well, and as I recall, you sent me the result of your search as far as how many times did the court refer to dominion in the
yes,
Johnson ruling. It was 13 times, as I recall. And the pairing of Christian people with dominion, i.e., domination, is really where the critical focal point ought to be. And yet, that's you have the one part of it, which is the use of Christian people, and then using fee and title, but staying away from the ultimate dominion, which is the theme of domination. So he has all the potential and capability of pointing that out, but declines to do so.
yeah.
Perhaps he didn't notice it. I don't, who knows what the reason would be.
Well, Steve, I think it's deeper than that, which is that there's a belief in the domination system. I mean, how can you be a judge and not believe in the domination system? You have the power to tell somebody you're going to jail. Okay, now we can justify that with all kinds of reasons and rules and talk about, how we get to enforcing proper behavior. But as soon as we're talking about that, then we're talking about force again. So there's a belief in a system which is hierarchical domination. The fact that in 500 years ago, all of those dominators wore Christian crowns is irrelevant to the fact of the domination. So you knock the crown off, you get rid of the Pope, you have King Henry, he's got the crown on. Get rid of King Henry, you get to the United States. What does John Marshall do? John Marshall says, oh, that crown fits pretty well. But I'm
Well,
not going to say it's
yeah.
Christian. I'm gonna justify it with some words here, but basically I'm also going to say that it's just a grand, extravagant pretension, but we're going to wear the crown. So the crown, the system of the US, I tried to show this in my most recent post, it's basically a feudalistic structure that has been carried on all the way through centuries and imposed without all the rhetoric. And so today,
Right.
what we're seeing here is the guy wants to erase more of the rhetoric. Let's get rid of more of the rhetoric. Well, what about this claim of the right of domination? Oh, I'm not going to talk about that.
Well, and if people want to understand the term feudalism, correct me if I'm wrong here, but they can think of it as a lordship system because the feudal system is based on lordship.
Yeah.
And there's a specific way in which that's written in Latin in one of the papal bulls, Domininiis, I believe it is. And however you pronounce that.
Yeah, Dominius.
So but the thing that I want to really lock in here on is the original free existence, and the ending of that free existence is nowhere to be found in any of this verbiage. That's the crucial point, that here are peoples, nations living for countless generations, completely free and independent of any of this foreign domination from Western Europe or Christendom. And then their free way of life is ended through the imposition of that foreign system. And there's no discussion of that whatsoever. It's all that's even further back in the background of the wording here.
Yep. And which is why I'm just trying to find that screen again, why here he's actually upholding that. The Stillaguamish are the original peoples in that land. How is it that they themselves don't retain the only ones that have power to determine when they may be sued? He doesn't.
Exactly.
He doesn't raise that question. It never occurs to him to say, "Wait a minute, how did Congress creep into this sentence here?" I'm
Yeah.
reading this sentence. I'm saying it's correct, but it doesn't really do what I think supposedly I'm after is some kind of what is he after actually? That's why I go back to the notion of he just doesn't like the emperor's clothes. He's not complaining about the emperor. I think there's one more thing. I think I can I quit sharing the screen?
Yeah, yeah. Well, before you do, one last thing. If you go way back to the opening of his words, Manja,
Yeah.
I just wanted to focus in on the word necessary. Remember, while it is certainly necessary to follow federal case law, okay? Pardon me. That matches Marshall's use of the word necessarily. Their
Yes.
rights to complete sovereignty as independent nations were necessarily diminished. Well, how were they diminished? By their imagining it being diminished. So their rights, so mentally they're diminishing it by saying it's not the full extent of what it was. But why is it necessary? It's necessary to the integrity of the system of ideas and arguments they're crafting and putting together.
Yes. And he is actually doing the same thing. He's finding language which is appropriate 200 years after Marshall was writing. And he's saying Marshall's language is inappropriate. We should use some new language here. Actually, I don't know what language he would use. He's the only language he adopts comes straight out of that thing, domestic sovereign nation. Well, domestic is contradictory to sovereign. So he's right in the thick of the actual case law here. But what he doesn't like is the sentiments, beliefs, and statements. It's like, well, how else could that be stated? Is what he's asking. Can we state the claim of congressional power in a way that's not offensive to my sense of propriety here?
Hmm.
Think this is all about and why it's useless, really. Can I stop now?
Yeah,
Because
please go ahead.
go to something you and I have said we got to talk about, which is that the using race critiques of federal anti-Indian law plays right into the hand of all the way back to Colonel Henry Pratt. The Oxford English Dictionary says that Colonel Henry Pratt, the guy who created the Carlisle so-called boarding school, that was the first written use of the phrase racism in 1902 when he was talking to the Friends of the Indians conference at Lake Mohonk. And his argument was that if we don't put these kids into the boarding schools, they'll stay Indians. And that's bad. That's racism. It's going to segregate them from the whites when they should be assimilated to the whites. So if you try to criticize federal anti-Indian law on the basis of racism, you're actually playing in to the entire fabric of the boarding school assimilation policy and saying,
Yeah.
yeah, if as soon as you open that door, you have opened, well, it's not Pandora's box. I don't know what it is. It's kind of like you've gone all the way back and short-circuited what you thought you were going to accomplish. You're criticizing federal anti-Indian law as racist, and then you find out, well, wait a minute. The guy was saying that it was racist if we segregated them and allowed them to have their own property, and their own property is getting in the way. That's his comment before he talks about racism. He says the Indians' property is the basic problem. As soon as we can solve that, the problem is solved.
I yeah, and I think that in addition to those points, when well, I'll give you an example. I picked up a book that was about the issue of racism and race and so forth. And I'm looking for a deeper analysis within the book for certain things, and I'm not finding it because where I would find that deeper analysis, I only find the word racism repeated over and over and over again,
Yeah.
as if that's adequate, as if calling it white supremacy and racism is sufficient. And
Yeah.
that's all that needs to be said. Well, what more what further explanation is there? What deeper explanation is there within the context of federal anti-Indian law? It's these deeper examinations of the nuance and subtleties of language and connections between synonyms and metaphors and analogies. There's so much that needs to be discussed that doesn't get discussed because that ends up being an endpoint rather than a starting point for
Yep.
for examination.
Yep. And I think, with all due respect, I don't think you claimed enough significance for what you just said, which is that the work that you and I are doing and a handful of others is to look at the chain of the decisions themselves, of the precedents. We look at the language they're couched in. Obviously, you can't get to the decision without looking at the language. But what persists through this whole history is the so-called precedent, the so-called claim of the right of domination. That's what we're looking at. And if all you're doing is criticizing the rhetoric that the claim is made in, this is what is hopeless. That's what you're saying. It's just, that's, again, it's like the clothing the emperor is wearing. The emperor says, I'm here to dominate. And why are you going to dominate? Because I'm white. Oh, that's a wrong thing to say. Oh, I'm going to dominate. Let me think. Counselor, give me another good word here. Oh, he came up with a good word for the public interest. I'm dominating for the public interest. Oh, great. Let's lock everybody up in the name of public health and public interest. Okay. Problem is solved. The emperor found some new language.
Well, and I think that the way in which the domination is there, but never explicitly acknowledged by the use of that word. Occasionally you'll see dominant, very, very seldom, but occasionally. And nobody looks at dominant and thinks domination. They just don't. It's not part of English to do that, okay? But what we've been doing is excavating, so to speak, those deeper, we've been digging down into those deeper levels of language, going all the way back in time to foundational documents and looking at well, for example, let's just take the word dominion. If you take the letter N off of the end of the word dominion, you get dominio, which is a verb, to dominate. And in the papal bull, you say que sub actuali dominio temporally. That's that word dominio. Stick an N on there. Now you have a noun, dominion. And what it does is it deflects attention away from the domination aspect of that and makes it much more difficult to comprehend.
Yep.
So it's those types of subtleties, sort of like, use a completely different example, whether the word people has an S and whether the S is before, excuse me, whether the apostrophe, so for a possessive, right? The apostrophe goes before the S or after the S on peoples. That's crucial because the first one before the S is individuals, and after the S is an entire people and another entire people and another one. So multiple peoples, right?
Yeah.
And those are the kinds of subtleties that we're paying attention to.
Yes, exactly. Now we're coming up on the hour. I wanted just to share the Pratt thing, so people can see that what we were just talking about. This is the 20th annual meeting of the Lake Mohawk Conference Friends of the Indian, notice 1902. And here's Colonel R.H. Pratt. I want to endorse what the bishop said. We'll skip that. And then here, in dealing with the Indian, the eternal thing with us is his property. Property is a stumbling block. I want to get it out of the way. So now make the Indian a man. Again, you think, wait a minute, you mean Indians are not actually full men? You made that point. When do you get to be a man? After you get civilized. Ability to take care of himself. Well, weren't they living here for thousands of years? So then here's the famous line: segregating any race or class of people apart from race kills the progress of the segregated people. Now notice he doesn't think there's going to be any progress of the dominators that's been going to be hampered, but just the dominated. Association of classes is necessary in order to destroy racism and classism. That's it. OED says that's the first use in writing of the word racism. And what is it all about? It's because here's the head of the boarding school process, the boarding school system, waving his flag and saying, we've got to get these people assimilated. We got to disconnect them from their property. And if we don't do that, we're committing racism, right? So the
Yeah.
attack on the Indian was justified as an attack on racism. So I'm just saying, be very careful when you start attacking the federal anti-Indian law as racist, is because it got started in the name of let's attack racism. I'm not all.
Well, yeah, I would go back to the use of the word bishop. So you don't have to show it, but because it's also showing the role of religion and churches in the overall process. But when you of assimilation, but when you look at that notion of property, if we were examining that still on the screen, we would see that he's basically saying the danger that exists for the United States is that a full right of property would be recognized as existing in the native nations. And one of the main things, I think the main impetus for the so-called boarding schools was to make sure that none of those children grew up with a sense of national identity as in other words, a national political consciousness on the
Free existence.
a free existence on the part of any native nation. So you make sure that the people are raised without that, so that they have no real political consciousness and a set of political skills that would enable them to advocate on the basis of their nation and their people, distinct and separate from the United States. That has to be eliminated completely. And you see that idea of inculcating, meaning pounding down into young children, the idea of patriotic values, patriotism for the United States. So it's a brainwashing process that's being engaged in with regard to those children.
Yeah, like a branding process, branding their minds. And this is the same guy, keep in mind, Henry Pratt, the phrase he uses that in another one of his comments to the Friends of the Indians is that kill the Indian, save the man. That's his
Yeah.
motto. And he says
Yeah.
that he kind of agrees with General Sherman. He says, I kind of agree with him. He says the only good Indian is a dead Indian. But he says, but unlike Sherman, I don't believe we actually have to kill them physically.
Yeah, and that's that genocidal process, the intention to destroy in whole or in part an entire people, but you don't have to have blood on the ground, you don't have to have bodies on the ground. You could engage in this long-term process of assimilating them, quote unquote, forcing them under the domination of another society and making them an integral part of that society, so they're identifying with that other society rather than their own. And that's the overall process. Going back to that word property again that he's using, if we remember that that word means domination, as William Blackstone called it, despotic dominion, the danger is that native nations would claim that despotic dominion for themselves, not that they believe in that, but to use that as an artful tool that would provide a shield, as so to speak, to protect them as a nation or people with a distinctive identity that's not overwhelmed and overrun by some other nation or people that wants to be invading and destructive to their existence.
Yeah. Steve, I think we're getting to the top of the hour, and I think what you just opened up is a whole new conversation about the extent to which it's possible in English in 2025 to make a statement that doesn't use the whole framework of property, dominion, et cetera, to defend something called sovereignty, quote unquote, another problematic word, saying, well, I'm here from the so-called tribal council and we're defending our property rights and our sovereignty and so on. That begins to be, I think what you're saying, that's something we need to look at in another podcast.
Yeah.
That sound good?
It sounds great. Thank you so much.
You too, Steve. Great. Thank you.
Take care.